Win today. Great. Great. Some energy. Okay, true or false? Declining number of mortgage origination would lead to a declining level of mortgage fraud. True or false? No. Incredibly false. Why? Well, the latest quarterly mortgage data from the Mortgage Asset Research Institute showed incidence of mortgage fraud in the United States increased 45% on fewer loan applications in the second quarter from a year earlier. And more than 65% of these mortgage fraud applications were due to misrepresentation due to name, occupancy, or assets. Surprise, surprise. Okay, the second most prevalent was fraud due to misstating income. That's 30%, and then 20% were on the applications. And why is this? Well, one of the reasons is because technology has increased pretty dramatically, so lenders and servicers and investors are much more aware of the fraud, so a lot of that fraud is actually getting caught now. But so the changing dynamics of the marketplace has forced the need for more technology to catch the fraudsters. The fraudsters are still out there. They're still going to do all of what they always do. But as we know, when times get tough, people tend, a lot of times, out of desperation, to lie, cheat, and steal. So just be aware. It's ongoing, and it's unfortunate. Okay, let's get on to some legal information. I want to talk about SB 1608, which is a landmark ADA reform. So I know most of us are involved. Either we own units, we represent sellers, or we represent buyers. But these are things you need to know. It targets ADA headhunters. Well, who are the headhunters? These are the guys who are out there looking for ADA violations and filing frivolous lawsuits against landlords. It received unanimous support by both houses of the legislature. Statutory damages are now based on each occasion that the plaintiff was denied full access and not by the number of violations of construction-related accessibility standards. So the plaintiff now can only recover if he or she experienced difficulty, discomfort, or embarrassment because of the violation, or was deterred from accessing a place of public accommodation. Now, what does that mean? Well, a person is deterred if both of the following apply. The plaintiff had actual knowledge of that violation, and the violation would have denied plaintiff full access if the plaintiff had attempted to access the property. So, if your property, and I suggest this is an important item to remember, if your property's been inspected by a certified access specialist, that's somebody you're going to want to know, you may have the right to a 90-day court stay and an early evaluation conference to evaluate the merits of construction-related accessibility claims against you. Just something else. Do I have a couple seconds?
A couple seconds.
Oh, good. Okay, because these are really, really, really important.
Okay.
And I forgot my watch today. So,
all right.
Domestic violence, AB 2052. Victims of domestic violence, sexual assault, or stalking are going to be able to break their lease without penalty if the following conditions are met. The tenant has to give a 30-day notice and attach either a copy of the restraining order or the emergency protective order, and a copy of the written report by a peace officer stating that the tenant or household member has filed a report alleging that domestic violence issue. The notice of intent to vacate must be given within 60 days of the restraining order or the police report. But you cannot charge that tenant any lease break charges, and you can't charge him any or try to get any concession payback. The tenant is responsible for 30 days after giving notice, even if the tenant vacates immediately. Okay? And there's a rebuttable presumption that the person who engages in domestic violence has actually created a nuisance. Now, for federal HUD Section 8 tenants, the individual can actually stay and the lease would be bifurcated and the perpetrator must leave. And lastly, this is really, really, really important. Open flame cooking devices California Fire Code. Open flame cooking devices in multifamily communities are now prohibited on patios and balconies, except when there's a sprinkler system in place to protect that patio or deck. Electric grills and the small liquefied petroleum cooking devices are okay as long as that capacity is less than 1 pound and it's kept 10 feet from the building. Grills can only be stored on a balcony if that tank is disconnected, and of course, you don't want to find a propane tank inside of the unit. And the need, this is important, if any one of you own any units at all, the need to serve a change in the terms of tenancy if the lease doesn't already prohibit open flame cooking devices. I have a lot to talk about, but we'll continue next week. So my name is Betty Donnelan. I have cards and brochures in the back. Have a